So hello everyone, welcome to this edition of 3PB's Case Law Update. I'm here with my excellent colleague Simon Tibbitts, who's a 2006 call and a specialist employment and discrimination law barrister. I'm Daniel Brown, also a specialist employment and discrimination law barrister, and together we're going to talk today about two cases. Firstly, one which you'll definitely have heard of, the big case of Asda Stores Ltd and Brierley, which the Supreme Court has handed down judgment in respect of this month. And I'm going to talk about a lesser known case, an ET decision, in fact, of Rodgers and Leeds Laser Cutting Ltd. It's a case concerning the scope of Section 100 of the Employment Rights Act, that is to say automatic unfair dismissal on health and safety grounds. But I'm going to ask Simon to make a start first of all with the Asda case. So Simon, the court's handed down its decision in Asda and Brierley. Can you remind me what the background facts are, please, and what are cross-establishment comparisons?
Thank you, Dan. Yes, nice to see you virtually, at least. So basically, this claim has been making its way through the courts since about 2016. It was concerned with effectively what was a preliminary issue, which was raised in the Employment Tribunal under Section 79(4) of the Equality Act. Well, I say that, it was actually under the Equal Pay Act and the Equality Act, but I'm just going to deal with referring to the Equality Act, bearing in mind where we are now in terms of 2021. As you and others will be aware, the whole purpose of equal value, not just equal pay, but equal value specifically, is that people doing one job can compare themselves to others doing completely different jobs. And this is what the claimants in this case sought to do. So as at the date of this appeal before the Supreme Court, 35,000 claimants employed in Asda's retail business, so that's what you, I, and everyone else will very readily recognise, the people working in store, have brought equal pay claims seeking to compare themselves to those employed in Asda's distribution centre. Now, the distribution business has got a bit of a history, and there was at one stage various contractors, and it was provided by third parties. But essentially, it's the warehouse where the products are delivered by suppliers, known as depots, and then they are sorted and distributed out to the store network. Now, the workers in the retail environment are predominantly female, and the workers in the distribution environment or the distribution sector are predominantly male. So that's the comparison that the claimants wanted to make for the purposes of their equal pay claims. The issue or the problem was that these retail and distribution locations, i.e. the stores and the depots, are geographically very much distinct and separate from one another. That meant the claimants wanted to make what is known as quite fancily, a cross-establishment comparison, i.e. to compare themselves with workers working in other locations. Now, Section 79(4) of the Equality Act allows for such comparisons to be made. The criterion are basically, or criteria, I should say, are A, B is employed by A's employer or by an associate of A's employer, not an issue in this case. Secondly, B works at an establishment other than the one at which A works, clearly the point in this case. And C, common terms apply at the establishments, either generally or as between A and B. Now, ultimately, therefore, the issue came down to the common terms issue, which effectively has not been further defined at any stage by Parliament. Now, at first instance, the Employment Tribunal undertook an elaborate exercise of comparing on a line-by-line basis the specific terms and conditions of employment of the distribution employees with that of the retail employees and concluding that they were broadly similar. However, pertinently, the Employment Tribunal went on to consider the North hypothetical. That is a principle that derives from the case of Dumfries and Galloway Council and North, the citation being 2013 ICR 993. Lady Hale in that case confirmed that this exercise was a purely hypothetical exercise of asking whether, assuming that the comparator was employed to do his present job in the claimant's establishment, the current terms and conditions would apply. The important point to note here, Dan, is that the second comparison the ET undertook is quite different to the first. In the first, they were comparing the distribution and retail workers' terms. They did that in quite a forensic way. And whilst the provisions of section 79(4)(c) appeared to allow generally as between A and B a comparison to be made, because none of the depot workers worked in the retail environment and vice versa, this was a rather artificial exercise in one sense. The latter comparison is obviously quite different under the North hypothetical, because there you are comparing the distribution workers' terms and conditions working in the depot with a hypothetical version of themselves working in the retail environment. In short, and cutting to the chase, the Court of Appeal, because it was appealed up through to the Court of Appeal initially, as one might expect, they held that the ET had erred in their approach to the former. They shouldn't have undertaken such a forensic line-by-line comparison. But they found that they had not erred in respect of the latter comparison, i.e. under the North hypothetical. Asda's appeal to the Supreme Court was essentially on the basis that they challenged the factual findings of the ET. And whilst in some ways they were criticising the ET for their approach in the former exercise, i.e. the line-by-line comparison between the retail and distribution workers, ultimately that was all a bit obiter, irrelevant, whatever you want to call it, because Lady Arden in the Supreme Court, as well as the Court of Appeal, had already held that the ET had erred in the way they approached that exercise. So all those appeal grounds were really just pushed to one side. So it was really on the North hypothetical where they were challenging the ET's factual findings. And in particular, that before the Employment Tribunal, they'd heard evidence about how the employment regime had been completely different in distribution and retail. But pertinently, there'd also been evidence whereby a couple of Asda staff had confirmed that if the distribution workers worked in the retail environment, i.e. had permanently transferred into a role in retail, then they would take on the retail terms. So accordingly, they were saying, well, the North hypothetical it is not made out from the claimant's perspective because their terms would not be comparable. They would have been the retail terms, which were quite different to the distribution terms. However, under cross-examination, those same witnesses, or one of them at least, essentially confirmed that on the situation whereby a depot worker was working from the car park, which was adjacent to the retail store, or if there was a till, slightly artificial hypothetical, but nonetheless, if there was a till at a depot, then they would retain the terms that they were currently engaged on, i.e. retail or distribution, and essentially getting to the point that the terms are those related to the function that the employee was undertaking, whether that be retail or distribution. And essentially, that was the evidence, and the representative for Asda, Lord Panic, was essentially saying, in a nutshell, that the ET had erred in the inferences they'd drawn by preferring one over the other.
So, Simon, there's been a huge media frenzy around this case. What did the Supreme Court decide, and why is there such a frenzy?
Yes, well, for employment practitioners like you and myself, Dan, I think that we may be a little bit underwhelmed. We see the media frenzy and we think, oh, this is going to be really interesting. And I do think this case is interesting for the reasons I'll set out in a while. But there's been the media flurry, first of all, I think, personally, because it's a large number of claimants, it's a household name, and if the equal pay claims are successful, and that's a big if, then obviously the back pay and the award is going to run into millions, if not billions. So that's why it's newsworthy. However, what did the Supreme Court find? Well, they effectively went through the pre-existing law, affirmed the North hypothetical approach, and upheld the same decision that the ET, the EAT, and the Court of Appeal had all found, which was, yes, the claimants can, in this situation, undertake a cross-establishment comparison in order to compare themselves, the retail workers, with the distribution workers. So it's not really, in terms of pure law, earth-shattering, I would say. Essentially, as employment practitioners like you and myself will readily appreciate, appealing on that a first instance decision, the tribunal have erred in fact, is often doomed to fail anyway, because we all know the cases. The tribunal is the primary fact finder. There's been numerous authorities whereby the higher court should not interfere with that unless effectively it is perverse to the extreme. So there was plenty of basis on which the ET could make the finding, and indeed Lady Arden in the Supreme Court readily agreed that it was appropriate to do so. So essentially that was the Supreme Court's finding. The claimants can compare themselves to distribution workers employed at different locations. I think the important point is that that maybe the media and some commentators have fixated upon in terms of this being a watershed moment, is that the Supreme Court was in some ways quite critical of employers taking this route, i.e. trying to dispose of equal pay claims at a preliminary stage by saying you can't make that comparison. There will inevitably be some cases where it is appropriate to do so, but they were very keen, and Lady Arden expressly set out, this is a threshold test. The threshold is low. The proper forum for determining whether a comparison can properly be made between retail and distribution is, in fact, during the various layers of equal pay, and especially equal value, which we're very familiar with. Is there a genuine material factor defence? Are they actually of equal value? There is a structure already set out, and that is the forum for undertaking that exercise. This is only for those limited class of cases, and she referred back to Lady Hale in the North case to emphasise that this is really to weed out those weak cases whereby the difference in pay is ultimately down to geography. There was another case in, I think it was Lord Bridge in Leverton I think it was that one, yes, whereby there was reference to the potentially historical factors. But realistically, I think that for practitioners, we're talking about geography here. So where the difference in pay and terms is really down to, for example, a north-south divide, that's the only function of section 79.4, really, to weed out those cases. Otherwise, you can compare yourself to someone doing a completely different job if you can establish that they are doing a job of equal value. But Lady Arden, in this case, was very clear to set out that this is only the very beginning of these proceedings. All that's been allowed is that they can principally compare themselves. They've still got to go through and establish that they're doing work of equal value, and they've still got to go through and defend any material factor defence that the respondent seeks to raise. And obviously, in this case, there's been a number of references, whilst irrelevant to the point before the Supreme Court, ultimately, but there's been a number of references throughout the judgment as to how these roles are, as one might expect, quite different. One's customer facing, one's not. The objectives are different, the time demands are different, the structure of work, etc., is all different. So there is quite a lot of difference. That's not to say that they're not of equal value. They may well be, but it's in its infancy, essentially. So it's got quite a long way to go. So I think the media are getting a little bit too excited about this. And comments from the claimants' representatives saying, well, we hope that finally they're going to come to the table and settle the back pay that is owed, with the greatest of respect, might be seen to be slightly premature, since this is really only the very start of the claim. But, stranger things have happened.
Thanks, Simon. I just wanted to check, finally, that given what you said about the Supreme Court's decision, is there anything else employment practitioners can take from this or can learn? What about using common terms and that concept or requirement to try and knock out claims at a preliminary stage? Is that going to be something that's an option in the future?
Yeah, I think that this judgment, and the reason why I say I think it's interesting, is because, as I say in my article, that this judgment, I think, will be the go-to judgment if an issue arises on section 79.4. And the reason I say that is because Lady Arden very clearly sets out the background law of how we get to this point of the North hypothetical. And I should stress that not always will the North hypothetical have to be applied. It may just be simple that they can say, look, these terms are broadly similar. We don't need to go down the North hypothetical. But where the terms are different on their face, and where you do have potentially no employees doing of the comparator in the claimant's location and vice versa, then the North hypothetical is being affirmed as the appropriate way to approach this. But what Lady Arden does do is she sets that out very clearly in her judgment, and at the end of her judgment, she sets out very clearly a summary over the course of about 8 paragraphs of the law, which practitioners always like ready guides, number one. And number two, she sets out guidance for case management of these cases in the future. Again, really emphasising the points I've already mentioned about this being a very narrow threshold test. Tribunals should not spend a lot of time dealing with this. They shouldn't go into a lot of detail. It really is based on this geographical or possibly historical factors that should be addressed. And considerations of some, a comparator being at the location doesn't have to be in the location. It can just be next to the location, like the car park example I mentioned in this case. So that is all really useful for practitioners going forwards. I don't think this is fundamentally a watershed moment, because I think it's just really affirming the pre-existing law. Can respondent employers ever use section 79.4? I think they can, But I think it's only going to be for respondent employers whereby genuinely, this sounds like stating the obvious, but genuinely where there is, for example, a north-south divide where geographic factors do impact on pay, then it can still be used as a mechanism for disposing of what is costly equal value litigation at a preliminary stage. But it's going to be the exception rather than the rule. I'll finish by just mentioning that in the judgment of Lady Arden, if I can bring it up, there, I touch upon this in my commentary, but lost the section in my judgment now, but effectively there is a hint at, in this case, there wasn't, for example, anything written down in the terms of the distribution workers as to if they moved to a different location, what effect that would have on their pay. And what I've sort of hinted at or referred to in my commentary, in my written article, is that this might be a way for respondent employers who genuinely do have differences in pay due to geographical factors. It might be worthwhile to fortify or strengthen their position on this particular argument, to actually make it explicitly clear that their pay is geographically dependent in the written terms of employment or in any collective bargaining agreements, and setting out what will happen if they move, that their pay will be reduced if they move south or whatever, because it takes account of those geographical factors. That might be a way to lay the groundwork for such an argument. But obviously the tribunal is going to be on the lookout for any sham terms. So this isn't sort of a clever way that I'm in any way suggesting that employers should employ. But I think it's something that where there are genuinely geographical factors at play, that those employers may want to consider that. I think that most employers who are sensible will take away, or large employers, I should say, who have got lots of people employed in different establishments, will probably want to take away from this judgment that if they haven't already, this is the time to review their pay structures, and just to make sure that they can justify, whether that be through job evaluation studies or whatever, that if they've got people working in disparate parts of the country in different locations doing completely different jobs, are they confident in defending an equal value claim in particular? Because obviously for large employers, the potential exposure, as you can see in this case, if it does go through all the necessary hurdles that are before it, is potentially significant. So Dan, from the weighty heights of the Supreme Court down to the humble employment tribunal, I understand you're going to be speaking about Rodgers and Leeds Laser Cutting Ltd. What were the issues in this case?
So Simon, this case is interesting because it raises a really topical concern, namely, what is the law in circumstances where an employee stays away from work because of concerns about coronavirus? And in particular, in this case, the issue was the claimant automatically unfairly dismissed within the terms of Section 100 of the Employment Rights Act because he stayed at home rather than attending work? So were there circumstances of danger which he reasonably believed to be serious and imminent and could not be expected to avert? That was the issue in the case.
So Dan, a little bit like barristers going to court, maybe. So what were the facts in this case?
Yeah, so the facts in this case were really quite stark and can be summarized under two themes. The first theme was that the workplace was generally safe. So the Employment Tribunal described it as being a large warehouse type space. it was clearly possible to socially distance. The respondent provided a face mask dispenser. Guidance was given about sanitizing and washing hands, and there were no criticisms of the employer's risk assessment or measures taken. No significant criticisms made in terms of the safety of the workplace. So that's the first theme. The second theme relates to the claimant's concerns, and namely the concerns were that he had a child with sickle cell anemia and a 7-month-old newborn. It follows that the claimant was concerned primarily for his family and was less concerned on the tribunal's findings with the safety of the workplace. He stayed away from home primarily, or on the tribunal's findings solely, because of concerns he had about coronavirus in the world at large and the effect that might have on the vulnerable members of his family. So those were the essential facts of the case, save to emphasize that this was a case of automatic unfair dismissal. He did not have 2 years service.
So what did the ET decide in this case?
So the tribunal put a lot of weight on the measures taken by the employer in terms of hand sanitizer, face masks, and in particular, the nature of the workplace being a large warehouse type space where it's possible to socially distance. It also attached weight to the fact that the claimant did not make any clear complaints or raise any clear concerns about safety in the workplace. In those circumstances, it looked at the terms of Section 100, and in particular, the question of whether there were circumstances of danger which were serious and imminent and which the claimant could not avert. And it considered the argument that under the health protection coronavirus regulations, which came into force on the 10th of February last year, coronavirus was declared to be a serious and imminent threat or danger to public health. But the tribunal did not think that that legislation or that declaration was sufficient to meet the statutory test. Looking at the workplace, it took the view that the workplace was not, did not involve circumstances of danger. And it took the view that it would be not something to be visited upon the employer for the employee to simply say, well, there's coronavirus in the world at large. It took the view that every employee would potentially be able to use that argument, and that was not, in the tribunal's view, the correct interpretation or approach to the legislation. Accordingly, it rejected the claimant's claim that there were circumstances of danger that were serious and imminent in which he could not be expected to avert, and the claim for automatic unfair dismissal was dismissed accordingly.
So Dan, do you think that employers can now rest assured that provided they maintain a COVID secure workplace, they can require all employees to attend work and dismiss those who refuse to attend because of the pandemic? And also, do you think it would make a fundamental difference if they were just bringing an unfair dismissal claim as opposed to just an automatic unfair dismissal claim, as in this case?
So yes, I think for 3 reasons, employers should not should not rest assured in light of this judgment. Firstly, as you rightly say, if the claimant was in a position to bring an ordinary unfair dismissal claim, it's far from clear that the claim would have failed in these circumstances. The tribunal noted at the end of its judgment that there were criticisms of the way the respondent handled the procedure, which led to the claimant's dismissal, but of course they were not relevant to the case before it. Certainly there are questions about when it would fall within the range of reasonable responses to dismiss an employee who is genuinely fearful of his health or the health of his family members, particularly if those family members are vulnerable in light of the context of COVID-19. These issues are going to have to be explored and decided on a case-by-case basis. So this judgment should not give too much reassurance in that regard, or in fact any reassurance. It simply does not deal with that issue. Secondly, I would say that there is ample potential, ample scope here for Equality Act claims. For example, I can think of a Section 15 Equality Act claim related to disability, where an employee says, I've got to stay at home because I'm vulnerable due to my disability. A dismissal could be unfavourable treatment arising from that. So there is plenty of scope for Equality Act claims, which again will have to be decided on a case-by-case basis. But thirdly, looking purely at this from an automatic unfair dismissal perspective, and in particular at Section 100, the tribunal's distinction between a safe workplace and the claimant's concerns about coronavirus in the world at large is an interesting one. And it appears the tribunal did not consider, in giving its judgment, an employment appeal tribunal judgment called Edwards and Secretary of State for Justice. Now, in Edwards, the situation was that the employees had to travel to work along a road which had been closed by the police or the highway authority due to adverse weather. On appeal, the EAT held that those were circumstances of danger, and it remitted the case to be determined as to whether or not the employees had a reasonable belief that the danger was serious and imminent. But it's also of note that in that case, the employer had sent some 4x4 vehicles to pick up the employees or the workers, and those who had refused to be conveyed in such vehicles were not paid. So it was a detriment claim, but essentially the issue, the legislation was very much the same in terms of the test of serious imminent danger, and the fact that the danger arose outside of the workplace was not a matter that led the EAT to have told that the claim should fail. So it does seem to me to be open in an appropriate case to argue that dangers outside of the workplace might potentially be sufficient. So the stage is set for an appeal, is what I'm saying. The judgment was only out this month, and so time is still ticking in terms of time to appeal. While many employers will, of course, find some agreed level of agreement with the tribunal's approach, they might say, well, it would be unfair if we have to continue employing people who will not attend work, even when we've done everything we possibly can to provide a safe workplace. It's likely each case will turn on its own facts, and it would be helpful to have some guidance from the EAT as to how Section 100 should be interpreted in light of COVID-19 and the issues I've just discussed, and in particular what factors should be considered when deciding whether the test is met.
Yes, it seems that it's going to be an interesting area generally to watch, doesn't it? Especially since we are coming out, in theory at least, on the Prime Minister's roadmap to recovery, that all restrictions as of June are going to be lifted, but people, for understandable reasons, have got quite strong views in terms of COVID, and everyone's situation is individual and different. So it's going to be interesting to see if we're going to see more of these type of cases, refusing to attend work because of fears of COVID, either put as an ordinary unfair dismissal, an automatic unfair dismissal, or discriminatory claims, as you've set out, are going to come to the fore, and we're going to see a bit of a wave of them as time moves on. Yeah, interesting one to watch. Well spotted, Dan.
Thanks, Simon.
So thank you all for watching. I hope that's been of some interest and use. Hopefully Dan and I and the other members of the Employment Discrimination Group will get to see you soon in person as restrictions are lifted. It's a sunny day outside today, so hopefully we might be able to have at least some sort of socially distanced drinks when the numbers are lifted. The details of how to subscribe to this podcast, but also other material that is produced by the Employment Discrimination Group, will be coming up on a banner afterwards, and our newsletter, which is edited by my learned colleague, Mr. Brown, will be issued shortly. Thank you all, and hopefully see you soon.